We'll be back.
Okay, stop.
Right. Hey! You can suck my head.
Did you know you're nasty? Did you know you're nasty?
After committing a you'd expect someone to have remorse and guilt. But today, we'll be going through these shocking cases where gruesome got more evil inside courtrooms and lost their conscience in front of the judge. 40-year-old Keith Ferguson's wife, Tiffany Ferguson, and her father, James Weber, on the same night in front of his 4 kids. He was charged with first and second degree murder, and on his arraignment showed a disturbing attitude.
Okay. Well.
All right, Mr. Ferguson, can I get you to stand up there at the podium, please? All right, I need to have you raise your right hand for me.
I'm leaving this
Okay,
court.
all right.
Just put me back in my cell.
Okay, stop.
All right.
The defendant has already murdered and murdered multiple people and fled and has taken hostages. There's no doubt in my mind that this particular defendant has a high risk of non-appearance or danger to the public.
We have issues of flight, home invasion, kidnapping. I'm gonna set it as a $10 million fine.
Everyone in the court was shocked to see Ferguson's demeanor, which seemed to change a lot during the sentencing hearing when he got much sober.
I knew one day you would kill her. She would always reply, "He loves his kids too much. He won't kill me." Well, we see how much you love them. You loved them so much, you murdered their mother and grandfather. Why? You could have just taken your own life and saved these poor kids, their grandmother, friends, and community a horrific pain. Do you have any idea of the emotional pain your kids have suffered and will continue to suffer their entire lives? Your Honor, on behalf of the kids, myself, and all of Chip's friends and family, please send Keith to prison for life without any chance for parole.
Tiffany's close friend delivered a heartfelt speech, and it was now time for the speak who showed no remorse at all.
Tragedy. Just sends me, kill me, whatever. And about the children, they've been through enough. And it would be good for me to, I don't want them to see me.
May not meet the clinical definition of insanity, but there's clearly something fundamentally wrong with you. You're incapable of understanding that intentionally depriving an elderly woman of her husband, her mate for life, and 4 children of your mother, to satisfy your own selfish urges.
Justice.
Is something that deserves the most important and serious punishment. You'll never again have an opportunity to hurt any innocent people. You'll never again have the opportunity to be free.
The psycho was sentenced to life in prison with no chance of parole. While this suspect disrespected the court, the next one took things up a notch.
Sit down. Mike, calm down. Relax. Breath. Mike. Breath. Put the handcuffs on. I'll put them on myself.
35-year-old Michael McDonald was released on bond when he violated a no-contact order that her wife had obtained to make sure she and her kids stayed away from McDonald. The state argued that he violated the parole by doing this.
His release condition was to have no contact with the individual, his ex-wife. Approximately a month ago in June, he then mailed a number of items to his wife's address.
Sent 2 gifts, that's it. No nasty notes with them. Mr. McDonald is not violent nor a threat to the community. He has had no allegations of violence.
Note that back in the family court, he constantly violated orders. He would always insist that the order said something else. I was the one who found that he was a potential danger to his children because he lied to the court about surrendering his weapons after he'd been ordered to surrender his weapons, and that because of his bizarre behavior, putting a tracking device on his wife's vehicle. And so I'm seeing the same type of conduct, and it's an obsession. It's a escalating course. I'm not sure that he is capable of controlling himself because he wasn't before. So based upon that, I am granting the motion.
The judge knew the case history and decided that McDonald had violated the no contact order. However, just when the officers came to arrest him, he lost control and did something shocking.
Hands behind your back. Put your hands behind your back.
Warriors had enough.
Mike, put the handcuffs on, or I'll put them on myself.
Hey, come on, Mike.
I'm on your side, Mike, put you out of line.
I just want to see my kids now getting prosecuted as an enemy of the state. I just want. I've done nothing.
Mike was later found guilty of multiple counts of forgery and about his divorce. On top of this, he also ended up picking a resisting charge. This suspect lost control, but the next one did something a little too much. 30-year-old Bass Webb was charged with attempted after he tried to run over 2 jail employees with his car. Webb, who had been in jail for 3 months earlier, arrived at his first court hearing and did something shocking.
Can you word your side?
Yeah.
That be yes?
Yes.
There's no way I want to try this case, or have any further proceedings, or I have to see you for one further step. Set for the very hearing next week. Charge me.
Mr. Webb literally spat at the judge and was immediately taken away. He was later found guilty of the charges against him and was sentenced to 37 years in prison. Suspects seem crazy inside courtrooms, just like this guy who did the unthinkable. David John was charged with sexual assault of a child and was calmly sitting through his first court hearing when he lost his mind and did something terrible.
You are charged with the aggravated sexual assault of a child older than 14 but younger than 17.
Did you learn your lesson? Did you learn your lesson? You need to learn your lesson so you don't end up like me. Get up. Get up.
You don't have a panic button.
Don't end up like me.
You okay, Mr. Randall?
Oh, no, I'm fine. I'm fine.
It was unclear what John was trying to prove, but he got no additional charges for this outburst. Moving on, the judge decided to teach the suspect a lesson in the next courtroom.
Hey, right now.
A disturbing stalker, Jacob Larson, appeared in front of the judge, John McBain, for a stalking case. It was the second time the poor woman came to court and complained to the judge about this creepy stalker.
She's instigating it, though.
Why do you feel that she's instigating?
But she's posting pictures and whatnot directed to me. All like a lot of makeup, hair done, all that stuff, like the full 9. She's, subtweeting me and whatnot on Twitter.
Is that true?
I don't have him on Facebook. I don't have him on Twitter. I have him on no social media whatsoever. My Twitter's private.
I want her to tell me to leave her alone.
You know what? I told you to leave her alone. And apparently that didn't get through loud and clear. So today, you're going to jail for 3 days. Bad attitude. You had a bad attitude last time you were in court.
You're going to her, our buddy.
45 days county jail.
Oh.
Okay. 93 days in the county jail. You want to go for a year? Try it right now. One more word out of you, it'll be a year of county.
Over Facebook. Like, really?
93 days in county.
I ain't never threatened.
Stand up. Cuff them. Stand up.
Buddy, more.
Stand up. You're going to a jail for a year in the county, 365 days county jail.
Can't do that.
Appeal it.
I will.
Good. Put your hands behind your back now.
Despite getting an additional year behind bars, Jacob wouldn't slow down, and that's when the judge decided to take matters into his own hands.
Taser right now. You taser right. You know what? I'll bust your arm. I'll bust your arm. I'll taser right now. Put your hands behind your back. We'll make it 93 if you can think about it. All right. Oh, good. Perfect.
Can't tell me to leave you alone. Can't tell me to leave you alone.
Judge McBain acted swiftly and helped his court officer control the suspect. This heroism is not often seen from judges, but McBain made sure to teach this stalker a lesson. This judge did a great job, but unfortunately, sometimes they end up on the receiving end of things. In January 20th, 24, 30-year-old Deobra Redden was at his sentence hearing after he was charged with an attempted case. Just when the district judge, Mary Kay Hothless, announced his sentence, he did something shocking.
That's what the laws of the state of Nevada, this court.
Redden was asking for probation rather than jail time, but he did something so stupid that he was now set to face multiple charges. And the worst thing was that he wasn't stopping.
Is she okay? Hey. Hey. Radio somebody? Give me all the arms. Radio somebody.
Oh, Shane, man. Shane's out of the hospital.
Oh my gosh, dude. Skin's hanging. No, come on, buddy. Call 911.
Keep jump for you.
Hey, where's Mary Kay?
She's right here. She's right here. She's right here. Man,
Stay down. Get on the ground.
is she talking?
Yeah, right.
Oh, shit. I got you. Yeah.
I got you.
Can I get a food sardines? The 3 friends.
Fucking asshole. Yeah. Oh, get him to bring you to the... Come on, get out of here.
Yeah, go ahead.
Immediately, every official in the courtroom helped restrain and hold down the crazy suspect. He continued assaulting them, hurling abuses that sent shockwaves through the entire room.
Hey, hey, my man. Yeah. Hey, you come here. I'll take care of him. That's my guy. Come around. Huh? You hold him. That's my guy.
Come around.
That's my guy right there.
Hey, Kelly, is medical coming? Hey, Doug, we got blood. Is medical
You guys got medical?
Just don't touch yourself.
Yeah, we need medical. Judge, you okay?
I got medical.
God, no. What the f? Shane, you alright?
Yeah? Hold him.
You're what?
Yeah, you guys got medical?
Yeah, what happened? What happened? He jumped over the bench. What? Are you okay, Judge? Medical's coming.
She's right here.
Shane okay?
Are you okay? Yeah, I'm good. Are you alright?
Thanks. That's my head into the wall.
Okay.
She out. She out. Huh? She out or is she? No, she was okay.
know what?
Just hit the head. I mean,
Grab this fucking
she
guy.
didn't really
Just
throw
get
any
him over
punches,
there.
but she hit her head on the wall.
Can you help him? Grab this fucking guy and get him over there. I'm not worried about the fucking.
Judge Mary had gotten several injuries, but luckily she was conscious, and EMS arrived in no time. The suspect was taken away and sent to jail immediately.
No, no. Oh, to bring him down. Yeah, to bring
She
him
hit
down.
her head, bro.
Yeah.
She hit her head.
She hit her head.
Hard. Motherfucker. Let's bring him around.
Sorry.
Get him in a holding cell.
You guys want to clear out?
Alright, I'm gonna get you in the chamber. You need to sit there. Let's get you into your chambers. Come with me.
The judge was treated for her injuries and returned to work in the next week. The incident went viral, and just days later, Redden was back in court, this time facing a slew of new charges.
Me appointing the public defender to represent him. There are multiple media requests. There were multiple orders that were signed in initial appearance court. I have amended several media orders to not allow live streaming because I do not allow live streaming. So to the extent initial appearance court allowed live streaming, I have amended all of those orders to remove that. I have filed amended orders yesterday. There are some new orders that I need to rule on, one from KLAS, one from Univision, one from Associated Press, and one from Fox 5. Does the state have any opposition to these media requests? Does the defense? Okay, I'm going to sign and approve these media requests. They are not for live streaming, and they are only for any sort of media that the media requested. All right, as for disclosures, before I arraign Mr. Redden, I want to disclose under Judicial Canon 2.11, Comment 5, that I do know Judge Mary Kay Holthus. I know her very casually and only professionally. I've never socialized with her outside, say, a professional event. I do, for instance, not know her phone number. I don't think she knows mine. We're not connected on social media. I've never worked at the district attorney's office, where I believe she worked for her entire career.
The presiding judge made it clear that she had no bias toward Judge Mary, and that the charges were only based on the law, with no emotions involved.
Her daughter is a deputy district attorney on my track. However, the team chief has assured me that Kennedy Holthus will not appear on any of Mr. Redden's appearances. Therefore, I see no reason to recuse. However, I make those disclosures under Rule 2.11, Comment 5. Mr. Redden, have you been given a copy of the criminal complaint this morning?
Yes, I have been given one.
You're being charged with count 1, attempt murder, victim 60 years of age or older, a felony. Count 2, battery on a protected person resulting in substantial bodily harm, victim 60 years of age or older, a felony. Count 3, extortion by threat, a felony. Count 4, intimidating a public officer, a felony. Count 5, 6, 7, 8, and 9 are all battery on an officer, the same named victim. Oh, and by the way, I do not know any of the other victims named in the criminal complaint. Those are all felony offenses. Count 10, performance of act or neglect of duty and willful or wanton disregard of safety or persons of property resulting in substantial bodily harm or death, a felony. Battery on a protected person, count 11, that's a gross misdemeanor offense. Count 12, battery by a prisoner, a felony. Count 13, unlawful act related to human excrement or bodily fluid, a felony. All allegedly occurring on January 3rd of 2024. Do you understand these charges?
This time, Redden was surrounded by security officials, and even after hearing all those charges against him, he couldn't think of doing anything silly.
Can you afford to hire a private lawyer at this time? I'm sorry?
I'm trying to,
Can you afford to hire a private lawyer of your own expense and choosing?
no, not at this time, no.
Are you a veteran or a member of our military?
No.
I can appoint a lawyer from the Public Defender's Office to represent you.
Thank you, Your Honor. And prior to Your Honor calling the case, I did, as a friend of the court, talk to Mr. Redden about his right to a Valdez-Jimenez hearing. I know that he did not have one in initial appearance court. However, he's going to be choosing to waive the prompt hearing given the circumstances that happened yesterday in district court where he's already been sentenced in his other case.
Okay, so he was sentenced?
Correct.
Okay, was he sentenced to jail or prison?
Correct.
Okay.
19 and 48.
Okay.
So he understood that and said that he's not trying to have the hearing today.
Okay, that's fine, and I'll canvass him on that. My only issue is I think what has happened is some standard bail figures have carried over since booking. So by the time he sees the judge, he is entitled to a Valdez-Jimenez hearing, but it is at that point that the court sets release conditions. So I'm removing the standard bail numbers that were only assessed at booking, frankly, until he sees the judge. And given the attempt murder charge of count 1, that is a set in court bail. So the standard bail numbers will be removed, It will be replaced with a set in court bail or release condition. He is entitled to a Valdez Jimenez hearing within 48 hours unless good cause shown. But you say, Mr. Redden, Ms. Medina tells me that without waiving a bail hearing completely, you're at least willing to waive it for now because you have some other issues you have to handle. Do you understand and agree with this?
Yes, in 1948.
Imagine ruining your entire life and getting 10 new charges just because you couldn't control your anger for a few seconds. He would be cursing himself for the rest of his life, the majority of which he would be spending behind bars.
So he'll just be on a set in court bail unless further ordered by the court. We need to set his preliminary hearing. Would you like that set within 15 days?
He's going to also waive the 15-day set and will do 30 days.
Okay. Sir, you have a right to a preliminary hearing within 15 days, and Ms. Medina has said that she's talked with you about that, and you're willing to give up that 15-day period and instead set your preliminary hearing within about 30 days. Is that okay?
Yes, that's fine.
Is this okay with the state?
Yes, Your Honor.
Okay. Does the state? Yes?
After we get the date, can we approach?
Sure. Is there anything else, Ms. Mercer, you want to address?
No, Your Honor.
Okay. All right. Here's a 30-day preliminary hearing date unless I see you earlier, and if you'd like to approach, you may.
February 14th at 9 a.m.
What's the motion? Thank you, Your Honor.
Hold on, because the enthusiast has to. There's like 4 buttons.
You're good.
He was taken away by the cops, and by the look of it, he was having regrets over his action. Here's another instance when a suspect lost control after he was sentenced for his crimes.
Is 50 years MSP non-good? Is 50 years with MSP?
You can suck my head.
In September 20th, 18, James Wasson entered a courtroom after entering a plea that would have shortened his 35-year sentence. However, the judge decided against it, which led to a shocking reaction from the defendant.
Court hereby sentences the defendant to 10 years MSP with 3 years suspended. And in relation to counts 2, 6, 7, and 11, the court also sentences the defendant to 10 years MSP with 3 years suspended on each count. Each of these counts shall run consecutive to each other. So the sentence in DC 17-267 is 50 years MSP.
No, I'm good.
Is 50 years with MSP, with 15 to be hereby suspended.
James, sit up. James, sit.
Take him out of here, man. In the matter of DC 277,
James was immediately grabbed and forced to sit on a chair. Lashing out at judges and contempt of court was normal for the suspect, as he had previously kicked down a courtroom podium.
the court hereby sentences the defendant on each 3 counts to 10 years MSP with no time suspended. So the defendant is hereby sentenced to 277 to 30 years MSP. The sentences DC 17-267 shall run concurrent to 277 and shall also run concurrent to the Judge Newman's sentence in 1788. You will have 120 days from today's date to review my written judgment to make sure my written judgment complies with my oral judgment in this matter, and the clerk will handle the necessary forms for sentence review.
And Your Honor, would also run concurrent to DC 17-278, which was judgment claim.
Oh, and it shall run concurrent to that as well.
Any sentence prior to today runs through here.
Right, and
He calmly listened as the judge announced his sentence, but he was about to have one last outburst, and this time directly at the honorable judge.
Your Honor, he has been incarcerated since the date of arrest, and we had that figured out the last time we were in front of the court. And we would add additional days as of from that last time. He was arrested on November 3rd, 2017. He would have credit from that date.
We shall give the credit, shall we give it to him?
Thank you.
Do you have anything else before this one?
Would be standard conditions of probation.
And during that time period, the court would also enter the standard surcharges and licensures and other standard conditions.
You can suck my
James. Anything further?
No, Your Honor, thank you.
James was ultimately taken away by the cops, as he had to continue his 35-year sentence. Next, this psycho killer bizarre reaction during her sentence.
I understand that argument. The doctor could just simply describe everything.
25-year-old Taylor Shabusinas, who was convicted and charged with murder and slaughtering his boyfriend, was at a court hearing when the court discussed whether the jury should see images of his boyfriend's head in a bucket. That's when the evil girlfriend started to laugh hysterically.
Although it's just kind of, in my opinion, sort of highly unusual that this picture, of the deceased would be presented to the jury when the doctor can easily testify about, the cause and manner of death. Pictures are going to really add too much, in my opinion, but I totally respect the court's ruling. I just want to make sure I made all my arguments to the court.
Sure. And I understand that. Photographs can be helpful to juries in understanding what witnesses are testifying to. For example, I think that argument could be made probably regarding every single photograph that's been entered into evidence, and that is, well, we can tell you what it looked like, and so you don't need to see a picture of it. Photos can be helpful. They can. And so I understand that argument. The doctor could just simply describe everything, but the question is this going to be helpful to the jury, and will the prejudicial effect outweigh the probative value? I don't think so. I do think it'll be helpful to the jury, and so for those reasons I'm going to allow it to be admitted.
Taylor proved that she was pure evil, and she was later charged with first-degree and was sentenced to life in prison. Well, that brings us to the end of this video. Today, we witnessed some of the worst criminals losing control in courtrooms. It's truly shocking to see them behave this way in front of a judge, proving one thing: they are dangerous and need to be locked away. If you agree with me, please consider showing your support by liking this video, and also make sure to subscribe to stay informed about future cases like these. Also, if you enjoyed this video, check out the next video here.